This is your jury charge for week number 15. Some of you had a difficult time with it. Let's see if we can find out why. Paragraph. You have now been sworn as the jury to try this case, period. This is a civil case involving a disputed claim or claims between the parties, period. Those claims and other matters will be explained to you later, period. By your verdict, you will decide the disputed issues of fact, period. I will decide the questions of law that arise during the trial, and before you retire to deliberate at the close of the trial, I will instruct you on the law that you are to follow and apply in reaching your verdict, period. In other words, it is your responsibilities to determine the facts and to apply the law to those facts, period. Thus, the functions of the jury and the functions of the judge are well defined, and they do not overlap, period. This is one of the fundamental principles of our system of justice, period, paragraph. Before proceeding further, it will be helpful for you to understand how a trial is conducted, period. In a few moments, the attorneys for the parties will have an opportunity to make opening statements, in which they may explain to you the issues in the case and summarize the facts that they expect this evidence will show, period. Following the opening statements, witnesses will be called to testify under oath, They will be examined and cross-examined by the attorneys, period, paragraph. Documents and other exhibits also may be received as evidence, period, paragraph. After all the evidence has been received, the attorneys will again have an opportunity to address you and make their final arguments, period. The statements that the attorneys now make and the arguments that they later make are not to be considered by you either as evidence in the case, or as your instruction on the law, period. Nevertheless, these statements and arguments are intended to help you properly understand the issues, the evidence, and the applicable law, so you should give them your close attention, period, paragraph. Following the final arguments by the attorneys, I will instruct you on the law, period, paragraph. You should give careful attention to the testimony and other evidence as it is received and presented for your consideration, but you should not form or express any opinion about the case until you have received all the evidence, the arguments of the attorneys, and the instructions on the law from me, period. In other words, you should not form or express any opinion about the case until you are retired to the jury room to consider your verdict, after having heard all of these matters, period, paragraph. The case must be tried or heard by you only on the evidence presented during the trial in your presence, and in the presence of the attorneys and myself, period. You must not conduct any investigation of your own, period. Accordingly, you must not visit any of the places described in the evidence, or the scene of the occurrence that is the subject of the trial, unless I direct you to view the scene, period. Also, you must avoid reading newspaper headlines and articles relating to this case and trial, period. You must also avoid seeing or hearing television and radio comments or accounts of this trial while it is in progress, period, paragraph. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper, period. When a lawyer makes an objection, I will either overrule an objection to the question, the witness will answer the question, period. When I sustain, or uphold, an objection, the witness cannot answer the question, period. If I sustain an objection, you must not speculate on what might have happened, or what the witness might have said, had I permitted the witness to answer, period. You should not draw any inference from the question itself, period, paragraph. During the trial, it may be necessary for me to confer with the attorneys out of your hearing, talking about matters of law and other matters that require consideration by me alone, period. It is impossible for me to predict when such a conference may be required, or how long it will last, period. When such conferences occur, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial of the case, period, paragraph. During the trial, we will take recesses, period. During these recesses, you shall not discuss the case among yourselves or with anyone else, nor permit anyone to say anything to you or in your presence about the case, period. Further, you must not talk with attorneys, the witnesses, or any of the parties about anything, until your deliberations are finished, period. In this way, any appearance of something can be avoided, period, paragraph. If, during a recess, you see one of the attorneys and he or she does not speak to you, or even seem to pay attention to you, please understand that the attorney is not being discourteous, but is only avoiding the appearance of some improper contact with you, period. If anyone tries to say something to you or in your presence about this case, tell that person that you are on the jury trying this case, and ask that person to stop, period. If he or she keeps on, leave at once and immediately report this to the bailiff or court deputy, who will advise me, period, paragraph. At this time, the attorneys for the parties will have an opportunity to make their opening statements, in which they may explain to you the issues in the case and give you a summary of the facts they expect the evidence will show, period, paragraph. Ladies and gentlemen of the jury, it is your duty to agree on a verdict if you can do so without violating conscientiously held convictions that are based on the evidence, period. No juror, from mere pride of opinion, hastily formed or expressed, comma, should refuse to agree, period. Yet, comma, no juror, comma, simply for the purpose of terminating the case, comma, should acquiesce in a conclusion that is contrary to his own conscientiously held view of the evidence, period. You should listen to each other's views, comma, talk over your differences of opinion in a spirit of fairness and candor, and, comma, if possible, comma, resolve your differences and come to a common conclusion, comma, so that a verdict may be reached and this case may be disposed of, period, paragraph. You may retire to the jury room at this time for further deliberations, period, paragraph.